The last report into sexual abuse and violence in Ireland, the Savvy report, is 16 years old. And although there has been an ongoing increase in the reporting of rape, the numbers of people who do so and who go through our justice system remain very low. The current court system often leaves victims saying that they feel demeaned and humiliated irrespective of what verdict is arrived at the end of the system. And we thought we would look at this in an in-depth way, and joining me to discuss all of the issues around rape and sexual assault and what needs to happen in our justice system is Maeve Lewis, who is director of the 1 in 4 charity, Frank Greaney, who is our Newstalk court correspondent, and we will be joined shortly by Noeline Blackwell, who's the CEO of the Dublin Rape Crisis Centre. Thank you both for joining me. I might come to you first, if that's okay, Maeve. We've talked about this quite a lot on the programme, and one of the things that has amazed me is the number of texts we get, and actually we've had some calls from people describing their own experiences. But what we see in the text line is they say, this happened to me maybe 30 years ago. I've lived with it every day since, and I've never spoken about it. I've had people on air with me saying, I've never discussed this before, but I'm listening to what you're saying on air and I want to speak now. Just describe for listeners, what is the actual, that corrosive effect that seems to happen to somebody who is a victim of a sexual assault?
Well, at 1 in 4, all our clients are adults who were sexually abused in childhood. And you know, while the abuse may have stopped many years ago, the impact of that abuse continues to contaminate people's lives right through their lives. Our clients typically may struggle with relationships. They feel themselves to be utterly contaminated by what happened to them. There's huge shame and stigma attached to sexual abuse still. So there are all sorts of problems that go on long into adulthood. And happily, more and more people are reaching out to services like 1 in 4 or the various rape crisis centres, be it in relation to child abuse or more recent sexual violence. I suppose the challenge for the services is that we all have long waiting lists, that sometimes people cannot be seen immediately when they pluck up the courage to ring, and that is a huge concern to us all. Do we know why, Maeve, you mentioned the word shame, why the shame seems to attach itself to the victim? I mean, I'm not sure that the perpetrators are walking around feeling half the level of shame that the victims are. Why is it that people, when this awful thing has happened to them, you know, it's been foisted on them by somebody else, why do they internalise the shame? Well, first of all, I suppose it's a very intimate violation, unlike a robbery or you know, physical assault of another nature. And certainly in the case of child sexual abuse, the offender is very skilled at making the child feel that it is something about the child that is forcing them to behave in this way, and also often warning of the dire consequences of telling anyone, you know, I'll go to jail, we may be thrown out of the house, there'll be no money coming into the house, so children, in addition to, and nobody will believe you, which is the big one. The abuse and the assault, there is an emotional manipulation, there is an emotional grooming, there is kind of insidious things said to them as well as the acts itself. Absolutely. And I think one of the really positive things about the big series of statutory investigations into the Catholic Church in the last decade of here in Ireland was that for the first time many of the people I would meet realised that they were not the only one this happened to. Very often survivors think, I'm the only person this has happened to, and suddenly people have realised this has happened to probably hundreds of thousands of people in this country, and that in some way diminishes the sense of shame. But that is one of the reasons, the shame, the stigma, that people are very reluctant to come forward to the criminal justice system. While you're a child, not being able to talk about it because maybe you've been intimidated or frightened into being silent, or maybe you don't have even the words to talk about it. That's very isolating. Very isolating, and maybe you did try to tell and you weren't believed, or people didn't understand what you were trying to say. People just couldn't believe that your dad or Uncle Jimmy or your mother had actually abused you in this way. Okay. I'm joined also by Frank Greaney, court correspondent for Newstalk. Frank, you have sat through some of the most heinous, I suppose, sexual and high profile sexual assault trials in the country. When you were sitting there and you were, you know, let's keep the focus for the moment on the victim, and you're seeing the system, the justice system sort of imposed on them. What were your observations about how it was for a victim going through that system?
Very difficult, I can imagine. I find those particular cases extremely difficult to cover as a journalist. The courts in Ireland, the Central Criminal Court, when it's dealing with these types of cases, does make certain allowances. Maybe they don't go far enough to protect a complainant when they're coming forward, but you have to remember that the person in the dock also has a presumption of innocence that remains throughout unless a jury finds that person guilty. When a victim is called to give evidence, or when a complainant is called to give evidence, they walk behind the dock, so they don't have to pass directly, past the person that they're accused of committing this crime upon them, but they are giving evidence just a short distance away from them, and while they're never within eyesight, they're just over their shoulder. And I often think when I'm sitting there on the press bench, I'm looking at them giving this evidence, how difficult that must be to be giving this evidence directly in front of the person that they're accused of doing this to them, especially when it's cases of historical child abuse. These are very, very difficult cases, and I can imagine for somebody sitting there in the dock going through and being asked the most graphic details about what's alleged to have happened to them. I always feel uncomfortable listening to that detail. I know how important it is for the jury to hear it, but like we were talking about before we came on air, what people hear in our news reports is only the tip of the iceberg, because you couldn't possibly report on the amount of detail that is being heard in court. So the public gallery is cleared, so it would only be open, the courtroom would only be open to members of the media and lawyers, and obviously the jury and the judge and that. So you wouldn't have members, the average punter, coming in and watching what's going on, and that differs from other jurisdictions, and we might talk about that in a while.
Well, yes, because you obviously were covering the Belfast rape trial, and obviously everyone was acquitted during the Belfast rape trial, but nonetheless it's referred to as that. And they have a different system where there is members of the public sitting in court, but there is a screen at the same time. Isn't the alleged victim, while giving testimony, behind a screen, and we have a slightly different system? Yeah,
so the complainant in the Belfast rape trial would have been considered by the court as a vulnerable witness, and let's remember that in all of these cases the person is considered a witness, a state witness, and usually the key witness on behalf of the prosecution. So when the complainant was giving evidence in the Belfast rape trial, they did make certain allowances. They pulled a large curtain across the dock so that she could not see the public gallery or the dock, which was directly in front of the public gallery, and it had the four accused. The only people that would have been within her eyesight would have been the judge, the lawyers and the jury. But then they mounted a camera in front of the dock, and that beamed live footage onto a screen that was directly in front of the four accused, so they could see her. But not only them, and the most troubling thing was that the members of the public could see, and that raised huge issues, and that wouldn't happen in Dublin because the public gallery would be closed for those types of cases. They would be heard in camera. We get a lot of things wrong in Dublin, but certainly that's one of the big differences.
There can be no public interest in having random strangers sit in and hear you give testimony about an alleged sexual assault.
No, you're
it's
right.
Not justifiable.
But it's not. But justice has to be seen and heard to be done in public, and that's probably where it's coming from. But I think exceptions do have to be made, and the likes of myself, my colleagues who are covering these cases, we satisfy that requirement because we're bringing these stories to the public, and it's very important to do so.
It's very interesting when you say that what you report is often the tip of the iceberg, because some of what you report, I've often sat in this room with newsreaders who go, and this report would be distressing to listeners, and I've often said to them off air, it's distressing to presenters too, because some of what we do here remains distressing. So if that's the tip of the iceberg, I can only imagine the level of
it's
awful
forensic,
detail.
Particularly cross-examination. Now, some barristers, defence barristers, approach cross-examination in these cases in different ways. Some barristers, with their clients' interests, at heart, they will become very adversarial. That doesn't wash well sometimes with a jury. Others will be a little more gentle-handed, but still, they're cross-examining them about very intimate details about the allegations that they have made, and it is very important for them to do so. But it makes for very uncomfortable listening.
And,
certainly.
We conducted some research with 10 of our clients whose cases actually made it to trial. It's called Only a Witness, and it's up on our website. every one of them, even though there were convictions, said if they had known what they were facing, particularly in cross-examination, they would never have made a complaint in the first place. And the reality is, I mean, especially with historic allegations of abuse, there are no witnesses, there is no forensic evidence, so everything hinges on the credibility of the witness, of the person who's making the complaint. And many defence barristers will do everything in their power to undermine that credibility. So the person's character, their behaviour over many years, perhaps some of the life choices they've made that are directly as a result of the sexual abuse, like developing an addiction problem or perhaps a mental health issue, are used to discredit them and to discredit their account. And that is absolutely devastating.
That's a very good point, because a good defence barrister, all he or she needs to do is raise a reasonable doubt for a jury to acquit. So if they pick little holes in stories, and over time memories fade, so particularly in cases of historical sex abuse, when they're talking about something that might have happened 20, 30, 40 years ago, and they're asked about minute details and they're proven to be inconsistent about those details, that must be very difficult then. So
even though we all know, if I asked you guys what happened 10 years, not about anything to do with an assault, but I said, where were you 10 years? And you were like, well, was I here? Well, was that summer? You know, all of us, our recall of the distant past is very difficult. We're going to take a short break. We're going to come back. My panel is Frank Greaney, Newstalk court correspondent, and Maeve Lewis, director of 1 in 4. We're talking about the impact of sexual assault and rape on people and what needs to change in our justice system. 53106 is the text line. Back after this. Now, you're very welcome back to Lunchtime Live here in Newstalk. We are talking about sexual assault and rape and our justice system and what would or should change. If anyone is distressed by what we're speaking about, let me give you out some numbers. The Rape Crisis Centre is 1800 77 8888. 1 in 4 is 01 66 24070, and the Samaritans is 116 123. If anyone is particularly distressed by what we're talking about, my guests are in studio: Frank Greaney, Newstalk courts correspondent, and Maeve Lewis, who's director of the 1 in 4 charity. I'm also joined now on the line by Noeline Blackwell, who is the CEO of the Dublin Rape Crisis Centre. Noeline, you're very welcome.
Thanks very much there, thanks.
Just with regard to you, I don't know if you were able to hear the conversation that we had before the break, but Maeve was talking about victims and the shame and how it is particularly difficult, the sort of dissection of their characters, the victims or the complainants when they're in court, as maybe has to happen to a certain extent. But the sad statistic, which is that a lot of victims say, irrespective of the verdict they get at the end of the process, they kind of wished that they hadn't gone through the process. It really wasn't worth it. Noeline, can you give us the kind of feedback that you hear from victims about having their own life under scrutiny because they've maybe been raped or they've been sexually assaulted, but suddenly how much they drank, what they were wearing, as we saw during the Belfast rape trial, the underwear and the clothes of the victims held up as evidence. You know, nobody under normal circumstance would ever want somebody to see their underwear, and yet this is held up in court. How does that impact on somebody?
So it is extraordinarily difficult, Ciara. So I suppose to put it in the context that you have been talking about it already, as you said, some of it is inevitable because for an awful lot of cases where somebody is raped, it's not a question of were they dragged down a dark alley by a stranger and assaulted, which in some ways is very straightforward. The question is, was there consensual sex or not? Because if there was consensual sex, there is no rape.
Yeah.
But if it wasn't consensual, it is rape. So there has to be a questioning and a focus on what actually happened. And what the courts have done, and again, like Frank would have been over this already, is they've adopted exactly the same approach as they would to somebody's phone or car being stolen. They just go into it in huge detail without recognising that these conversations are that what somebody is being asked is precisely the course of the injury. It's like if somebody was injured and the court went in and actually poked around the injured part of the person. And that's what that's why these are so difficult for people. People who go into the court system, from what we know about it, where we're talking about the people who have been assaulted, it is hard enough to make the decision to report.
Yeah.
And then to have to go in and have your credibility as the victim is key to the assessment of whether or not there was consensual sex. So your credibility as the victim is being assessed in huge detail, and all that the jury has to find is that there is a reasonable doubt about what you say as the victim, whereas the accused person must be found guilty beyond all reasonable doubt. And in a sense, there's no problem with any of that. For people don't mind being asked what it was about, but it is the way in which you can be harassed, the way in which your credibility can be assessed, the histrionics of the court system that victims find very hard to take when they are talking about something that is possibly the most painful thing that ever happened to them in their lives, and they're being criticised when they don't remember it in exactly the same way, or they're being criticised because they remember it in exactly the same way, that they're accused of being coached. And so for them, a lot of them will come out and say at the end, I am still glad I reported. I needed to report because I don't want that to happen to anybody else. I needed to report because that has happened to me too often and it had to stop. Yeah. So, but nonetheless, it is the process of getting at credibility is just treated like
extremely
any
difficult
other crime and not suitable to intimate violence.
Yeah. No, I know, and I can only imagine, like, obviously there's a presumption of innocence, but supposing somebody isn't innocent and supposing they are guilty, then in that case the victim it's extraordinary. I want to bring you back in, Frank, on the whole issue of sentencing and leniency. We've had a couple of high profile cases lately. We had John Joe Kieran, a suspended sentence for his conviction against rape of children, historical rape of children. I don't know if historical makes it better or worse that he got away with it for so long, but he had a suspended sentence. And of course, more recently, Owen Berkeley, who raped that Spanish student in a tent, 14 years. Massive disparity between sentences, and the kind of things that are brought in that feed into the sentencing, things like previously good character, mitigating circumstances. I have to say, I think you've de facto lost, once you've been convicted of rape, any previous history of good character should be wiped out, because you're clearly not of good character. You're now a rapist.
Yeah, look, there's an awful lot that a sentencing judge will have to take into account, and there seems to be a bit of a mystery surrounding it, but it is quite a complicated process. It's not just a matter of the judge going back to their chambers after a trial, rolling a magic ball and a number comes up, and that's how many years you're going to prison for. When it comes to rape, which is considered one of the most serious offences in the state, along with murder, it carries a maximum penalty of life imprisonment. It doesn't have a mandatory sentence like murder. It doesn't have a minimum or a maximum.
We don't see
sentence.
Many life sentences passed to rapists, irrespective of the Owen Berkeley case had a lot of very distressing evidence given and distressing facts put out there about what had actually happened to that girl. Yet 14 years is considered a meaty enough sentence now for a rapist.
I know, but when you take into account that if somebody is convicted of murder and they're handed a mandatory life sentence, that doesn't mean they're going to spend the rest of their life behind bars. Owen Berkeley may end up spending just as much time behind bars as somebody that is convicted of murder. 14 years, given the fact that the average, and I know there are huge disparities, but given the fact that the average sentence served by a convicted rapist is about 10 years, the average sentence handed down rather, they mightn't spend that long behind prison. So putting that into perspective, Owen Berkeley's sentence is well above the average. I do think, and the judge did say this, he did say that the court wasn't optimistic that Owen Berkeley could be rehabilitated, and that is obviously a huge factor that a court takes into account. And I've pulled a quote from his judgment. I went through it this morning again in relation to the Owen Berkeley case, and this is in relation to sentencing as a whole. He said the court has a general duty when imposing sentence to protect society. It also has a duty to punish, to deter others, to rehabilitate. A sentence must be proportionate, and the totality principle must be taken into account when considering whether a sentence should be consecutive or current. Now, each sentence is tailored according to that individual case, and a judge, you mentioned earlier, will take a number of factors into into account mitigating factors, aggravating factors. The most significant mitigating factor would be a guilty plea. Owen Berkeley did enter a guilty plea and he would have been given a significant discount for that. Previous good character, things like that are also taken into account. Owen Berkeley did not have a previous good character.
He was out on bail and in breach of his bail.
He had 25 previous convictions. He was serving. He is currently also serving a prison sentence for wandering around near Dublin Airport with an imitation firearm, a very serious offence that he was handed a 2.5-year sentence for. That would have worked against him. Lady Justice, we're all familiar with the Lady Justice with the balancing scales and the sword and the blindfold. The scales are very important because these factors need to be considered and weighed up in relation to the offender and the circumstances of the case. So there's a lot taken into account.
Can I just bring you back in briefly, Maeve, because unfortunately we're nearly out of time. You heard there from Frank what a court has to take into account when passing sentence, by way of leniency or, there's protection. Do we do enough to protect society in general? If the court says things like, we don't hold out much hope that this current rapist we're discussing, Owen Berkeley, that he will be rehabilitated and he will continue to therefore be a risk to society, should we think of things like whole life sentences for people that we know will come out, and if they re-offend, the nature of the crimes they commit are so heinous, should there be a lock them up and throw away the key?
No, I don't think there should be. I think sentences should be commensurate with the offence, absolutely. But I do think there is a possibility with good treatment intervention programmes to offer some hope of rehabilitation.
You guys have your Phoenix programme.
We have the Phoenix programme. We work with about 50 offenders a year, and while we can't talk about cure, we certainly can talk about people taking responsibility for the triggers that lead them to sexual offending, and also for the support they need to live in the community and manage those offences.
And do you believe those kinds of programmes that, I suppose, re-educate sex offenders to maybe understand the impact of their crimes and therefore be less likely to offend again are more effective than prison terms?
I think both can go hand in hand. And we talked about shame earlier, Ciara, and when offenders really begin to understand the impact of what they have done, then you see people with absolutely intense shame and recognising what they have done. But sentencing is important. But the problem is so few offenders are convicted. We estimate that fewer than 5% of people who sexually abuse children are ever brought to trial, never mind convicted. And last year we supported 31 people through the circuit courts and the Central Criminal Court. There were 5 guilty pleas. There were 11 guilty verdicts, jury verdicts. There were 8 not guilty verdicts, and there were 4 hung juries where the trial collapsed. Now, do I believe that our clients were telling lies about what happened to them? No, I don't. But do I believe that we need really to look at our court system? On the one hand, there has to be a very high bar of proof, but on the other hand, people's accounts of what has happened to them, and of course protecting other children, has to be paramount. And Charlie Flanagan, Minister for Justice, is currently reviewing.
We need another savvy report, and we need Charlie Flanagan to implement change. Lastly, 1 in 4 has an event tomorrow evening.
We do indeed. We've just talked about the fact it's so hard for people to talk about what happened to them. So this is a wonderful project called Photo Voice with Dr. Maria Quinlan and Patrick Bulger. They worked with 8 of our clients. We gave them cameras, and they have taken photographs which articulate their experience and put words with it. And Ciara, you very kindly have offered to MC a short panel discussion, and it's in the Woodkey venue at 6 o'clock tomorrow evening. All
right, listen, my sincere thanks for talking to me about this. Maeve Lewis, director there of 1 in 4, Frank Greaney, Newstalk Cork correspondent, and Noeline Blackwell, CEO of the Dublin Rape Crisis Centre. I am afraid we are out of time today.